Uh, Good evening, friends. Welcome to this Friday webinar. And today we are on a topic which is so interesting. And, I speak about that there are three kinds of markets for professional. Perfect market. You do income tax, GST, audit. Then there are monopolistic market where there are few suppliers of services and many buyers. And there is a monopoly market. SEBI is one such market where there are very, very few specialists. And we are so lucky that Advocate and Company Secretary Rakesh Puri Saab is with us. He is a corporate lawyer, very humble, ready to share 100% of his learning. And my experience of life is those who share 100%, they are the maximum beneficiaries. Because knowledge is one product which increases by sharing. Like on the screen, there are three persons. Lokesh Agarwal from Guwahati, Rakesh Puriji, and myself. On, this platform, there are 299 participants. So suppose, and we are 302. And each one of us, if we have one idea and we share with everyone, each one will have 302 ideas. So I want each one of you to become, each one of us, I prefer to use the word us rather than you, should become a writer, should become a speaker, because that is an evidence to receiver of service to come to us. And by that process, we also expand our knowledge. Another thing which I, very vehemently request each one of us is to use social media. There are more than 30 platforms. Most common which we use is Facebook, LinkedIn, but there is a blog, there is a YouTube channel, there is a Instagram, Twitter, there are podcast platforms. And by posting, 500 crore people use social platform. So rather than for social occasions, for our knowledge, we should share on social media. This committee is also bringing out various publications. So if you are interested on writing on any subject, do let us know. Put your query in the chat box. So if you have any query, I can answer that. We are also coming out with Train the Trainer program. In the whole country, we will do 15 to 20 programs. The first program for this year, we are doing next week in Raipur, which is in Chhattisgarh, capital of Chhattisgarh. So if anyone who is interested coming over there, but we will do in different part of the country. So Parth, any query, any participant has posted? I'll give 1 or 2 minutes and then we can start on the topic, which is very interesting, compounding under SEBI law, the application to Securities Appellate Tribunal, and things like that. So Lokesh, you can carry on because participants will take some time to post queries.
Thank you, sir, our chairman, sir, for this wonderful enlightenment. Good evening, everyone. I am Lokesh Agarwal, moderator of this VCM. Before starting today's session, I would like to apprise you about the 21st World Congress of Accounts, which is going to be held in India for the first time from 18th November 2022 to 21st November 2022. To know more about this, I would like to request our technical team to play a short informational video. Please see this and register yourself for the same. Over to technical team.
Geographically, the 7th largest country in the world, one of the oldest civilization, world's 6th largest economy, a global hub for innovation with one of the largest startup ecosystem. India, city of Mumbai on the western coast of Arabian Sea, among the most advanced and modern metropolises in the world, and the financial capital of India, gears up to host the most prestigious accountancy event of the world, 21st World Congress of Accountants from 18th to 21st November 2022, an event held every 4 years. The Olympic of Accountancy Profession. India hosts the event for the first time in 118 years since the WCOA came into being in 1904. Around 10,000 delegates expected to join virtually. More than 6,000 delegates from over 135 countries would congregate to exchange views at the world's most advanced Geo World Convention Center. The theme, Building Trust, Enabling Sustainability, will inspire the future of accountancy profession to create sustainable economies for the future.
The ICAI is honored to be the host for this mega event, which will bring together the world's largest conglomeration of professional accountants, regulators, leaders, and visionaries to advance the cause of the global accountancy profession. Now, with the ease of travel restrictions across the world and the situation returning to normal, we are working towards creating a never before and a unique experience for all our delegates. The year 2022 marks the 75th year of India's independence, and the Government of India is celebrating the year in a big way to showcase the glorious history of India. World Congress of Accountants 2022 would also be celebrated as a mega event to showcase the important role that the accountancy profession has been playing in the economic and social development of the country.
A never before witnessed unique experience of learning future trends, emerging avenues, enhancing skill sets, networking, and to explore the incredible India awaits you.
We at ICAI are pleased to host you here in Mumbai, the financial capital of India, for the 21st World Congress of Accountants with the theme Building Trust, Enabling Sustainability from November 18 to 21, 2022, and give you a professionally enriching and personally rejuvenating experience. We are hopeful that the conference shall be stimulating and productive, and your stay in India will be a memorable experience. Once again, we invite you for this enthralling convergence in India, the land of multicultural, historical, and spiritual inheritance since centuries.
Insights from the stalwarts of the profession, international and national standard setters, regulators, and trendsetters will constitute the panel of speakers at WCOA 2022. Let your dream get bigger. Come, be a part of this mega celebration. For registration and sponsorship opportunities, contact. Organized by Institute of Chartered Accountants of India under the aegis of IFAC.
We are delighted to welcome you all in the webinar being organized by the CECLEA Committee of ICAI. It is my pleasure to be a moderator for this session on webinar on SEBI, Powers and Functions, Penalties, Adjudication, Settlement, and SAT and SC Appeal with case laws. In a short while, we will start this webinar. Before that, I would like to appraise you about the CECLEA Committee. The committee, in line with one of the Institute's objectives, partner in nation building, and with a vision to contribute to economic development of India, aims to undertake such activities on to technically equip, broaden the scope of expertise of the members to enable them to drive advantage in the rapidly changing scenario, and to enable the members to render various business advisory and support services. The program for this evening is as follows. We have one session of 2 hours, and the topic, as I already said, is SEBI, powers and functions, penalties, adjudication, settlement, and SAT and SC appeal with case laws. Before handing over to our eminent speaker, I would like to give an introduction of the speaker. A short profile of CS advocate Rakesh Puriji. He has been a graduate in law and is also CPA from the USA. With over 25 years of experience, he has gradually led in-house legal teams in complex joint ventures, overseas setups, FDIs, ODI investments, financing agreements, and providing litigation strategy as well as legal advice and counsel. He specializes in banking and finance, capital market and security laws, company laws, RBI, FEMA, NBFC, arbitration, and contracts. He has been a regular speaker at various programs of ICSI and law universities. He is also the co-author of the book Guidance Note on Internal Audit of Stockbrokers, published by ICI. With these few lines, I would like to invite CS Advocate Rakesh Puriji to carry over this webinar and enlighten us with his knowledge.
Thank you very much, Lokesh ji, for your grand introduction. At the outset, I must thank Institute of Chartered Accountants of India and its office bearers, Dr. Rajkumar ji, Hansraj ji, Lokesh ji, Reena ji, Krishnakant, and others who are involved with this program. It's a great opportunity for me to share my experiences in the securities market, in accounting, as well as in the legal field. As Rajkumar ji also pointed out, it is something which is unique. SEBI laws or PMLA or SFIO, it is something unique. And it's basically, though we study it in our curriculum, very few venture in the real practice of it. Because we have audit opportunities, we have finance opportunities, we have tax opportunities, as well as GST opportunities. So here, the objective is continuous professional, through CPE, we continuously evolve and meet day-to-day challenges which come to us every day. The world is changing fast, not to worry about it. We are equipped much more to face than this world is. Uncertainty, complexity, ambiguities every day, are increasing. But we have been trained in our exams of Chartered Accountancy or CS or cost accounting to face them. What happens is, if these continuous programs don't happen or are not attended from the heart, then we lag behind. And that is why the two prestigious institutes, Chartered Accountants as well as company secretaries, they have evolved mandatory continuous professional education. It gives the opportunity for the seniors to share their experience and also for the others to learn from it. And let me tell you, learning never stops. It is everyday affair. Those who refuse to learn are already dead. Let there be curiosity. Let there be knowledge seeking every day. Even if I do not know the meaning of, say, a particular word, I should be eager to know. And nowadays, Google Devta is there. He is 24/7 available to us. And of course, all the information from Google Devta is not right. You have to refine it in your own way. So before coming to the subject, let me tell you some things which I find dealing with chartered accountants, Big Fours, as well as my friends who are not a part of Big Four, but very knowledgeable. You see, subject knowledge is different. It can be learned, but personality development is what is more important. once we have the right traits of learning, sharing, caring, and eagerness to work in teams, IQ automatically improves. But these four things which I said, they come from EQ, emotional quotient, which is very important. I may be brilliant individually, but if I can't be a part of the big teams, nowadays everything happens through teams. No person can work individually. It happens with team. You have to adjust to the people, their nature, their weaknesses, their strengths, and accommodate yourself and make a place as contributor. So that trait will come to us only when we shift from individuality to personality. And for bringing that change, I think we are all grown up, we are all well settled in our life, but this has to go on. I have to become more humanistic. I have to be more a contributor rather than demanding and complaining and accusing the system or anybody else. Let me be a contributor from ARC, that is accusing, ADC, accusing, demanding, and complaining. Let me become LRC, loving the country, loving fellow beings, and cooperating them. From ADC to LRC is the human excellence journey. It is a path as well as a goal for all of us. So my request to all my brothers who are accountants here, let me tell you, I started my career as an accountant, and I am proud to be an accountant. Of course, not from India, but from USA. But I started my career at the age of 16 at rupees 12 per day as an accountant. And I got scolded for the slightest of the mistakes in the hall in the presence of 25 people. I did not feel bad, but I have become better, perfect because of that scolding. And it was a very good company at that time. So I learned accounting from there. From there, I have gone on to become and be a part of the corporate laws, governance, finance, legal, secretarial, and any commercial aspect. So let accounting be not seen as something which is trivial, which can be handled by the system. No, as humans, as accountants, we can always add value to it. I remember Nani Palkiwala asking one of his accounts people, what do you do every day when you come to the office? He says, I read 3 principles of accounting every day, and that is what makes me run this huge organization. I think this happened in ACC Limited. So accounting, tax, audit, governance, SEBI laws, economic laws, Competition Act, all these things are important. But can I do all? Obviously, in isolation as individual, I can't do all. But I can always be curious to know, to learn the basics of it. That is where, the evolvement stays. The curiosity to learn should always stay in us, not when the institute has given us the ACA number or FCA number. It should not stop at that. The journey restarts because now you are a part of a bigger, larger family than you were on the other side. Of course, numbers on the student side is always more, but now here you have a responsibility to carry out the brand of your institute and of yourself. Your very behavior, your very conduct, your talk, that will showcase how the professionals are or how a common man will perceive us. So it's a huge responsibility on all of us, and we must carry it out so that from individual we become person and we become a contributor. Love, respect, and cooperation from demanding and complaining. All right. So, and that how that will happen, before I come to the subject, I will tell you that. physically strong and healthy, mentally alert and sensitive, and spiritually united. That is the way and goal for all of us. I'm saying it all of us because I'm also included as a student. Though I may be talking to you, but I still remain a student of accounting, law, tax, and everything which is worthwhile. So with this background, let me now start the topic. I'm unable. Are you able to see it? Yeah, एक second. View. Yeah. Is it visible to you, the participants? I can ask only through this thing. So the subject before us is securities laws, SEBI, Securities Exchange and Board of India, its powers and functions, penalties, adjudication, settlement, SAT, and Supreme Court appeals with case laws. It's a very huge subject, as you know already. I will be talking from my experience in capital markets, as well as in my practice of corporate laws. In fact, today I had 3 laws to deal with. I had a hearing before NCLT on IBC, on company law, reduction of capital under section 66. Then I had some settlement stuff going on with SEBI. And fourth, I was to deal with Grant Thornton for signing of some financial statement. So in today itself, I have covered almost 3 or 4 areas of commercial laws. But it gives you happiness when you contribute something to it. Capital market is very vast, ever evolving, and it keeps you on your toes. Index is up, Sensex is up, we are happy. Sensex is down, we are unhappy. But nowadays, of course, one has to be an investor in it to derive interest from it, to get that excitement of making money or losing money. One has to be a part of it. But the headlines which every day comes are so and so levied penalty of 500 crore, so and so debarred from market, so and so auditor debarred from taking further assignments, so and so asked to disgorge 5 crore. For front running, fund manager asked to disgorge so much amount. Every day, the orders of SEBI are there, and very strong order. And penalty is there, restraint is there, disgorgement is there, insider charges are there, fraudulent and unfair trade practices are there, auditors are being summoned, secretarial auditors are being summoned, and whole board of directors is being summoned by SEBI in investigations. It's a very exciting area, but one has to have basics in place. And I always say in all of my lectures that you can understand securities laws better if you yourself are an investor. It doesn't matter whether you are a big investor or a small investor, but you should be an investor. You will come to know the process of opening a demat account or a trading account, as well as you will learn the art of applying in the FPOs, IPOs, or rights issue, as well as dealing with your demat account. So unless you get used to these processes, you will not understand this dynamic law, which is Securities and Exchange Board of India. And it's evolving every day, it's changing every day. As we will see in the course of my talk, more and more people are getting involved with it. So before I go further, as a lawyer, I have to say that this talk is not intended to be advertisement or solicitation. This is only for private circulation, just to express my views and for advice. The professionals may be approach on any particular topic. That is a disclaimer I have to make. Now, the big boss of capital market, what he says about the capital market? He says, I will tell you how to become rich. Close the doors. Be fearful when others are greedy. Be greedy when others are fearful. This is Warren Buffett, billionaire and CEO of Berkshire. And another stalwart, he says, if I had only followed Business Channel's advice, I would have $1 million today, provided I had started with $100 million. So you know the value of Business Channel's advice. So what it says is that use your own mind, your own research, your own experience. And in the last annual general meeting, what Mr. Warren Buffett said, he says, sometimes the stock market is quite investment oriented, and other times it is almost totally a casino, a gambling parlor, and that existed to an extraordinary degree in the last couple of years, encouraged by Wall Street. It's a very big statement, and I don't think I need to elaborate it. Suffice it is for me that sometimes the system that itself becomes full with the anomalies, and it leaves a lot of part of it as a for speculation, as a casino. I think that is the challenge for all the regulators, that they don't allow it to become a casino for a long time. Now coming to Indian market, how big it is. Intermediaries, you cannot do anything without intermediary in capital market. We have stock exchanges, we have brokers running into 4,700, derivatives brokers 3,600, currency derivatives 3,000, commodity 2,000, clearing corporation 5, FPIs 10,000, custodians 18, depositories 2, DPs where we have our demat account about 300, with NSDL 615, with CDSL, merchant bankers around 215, bankers to an issue, KYC agencies, RTA, investment advisors, mutual funds. So many people are there. So there are about 40,000 intermediaries who are registered with SEBI, who cater to different parts of the capital market. It's a huge infrastructure, and all of them are registered with SEBI, and they have to renew their license. SEBI sees the fit and proper person criteria, plus the infrastructure facilities, plus other applicability of the regulations when they renew it or they give the fresh registration. This itself is a big opportunity for many, to give professional advice at the time of registration with SEBI. I think the assets under management of mutual funds is around 35 to 36 lakh crores, which is better than what we had 2-3 years back. But yet the FPI holding, I think, is much more than this, maybe 44-45 lakh crores. I think it should be the reverse. Mutual funds or Indian entities, they should be holding much more of the capital market than the FPIs, because we cannot depend on them. They are very opportunistic. The moment they see a fall, they just take away their money and go to other markets. Only the domestic participants, retail participants, they stay glued with the Indian capital market, because they are convinced that India is a rising country and it will give returns, though there is a fall of 10,000 points in the last few months, but that's okay, not to worry much. Long-term players, they do not worry about the short-term losses. And this capital market, I must tell you, will teach you only after taking good Guru Dakshina. It does not give free knowledge. It will give you experience for a good amount of money, and then good amount of money for the experience which you have. Nothing is free, no free lunch. You learn by losing money. Next time you become smart, still you make money, and then after some time you may lose money. We have seen biggest of the IPOs failing, subscription being many times and opening being bad. Even if opening is good, after some time they just lose the steam. We have seen it in LIC, we have seen it in Zomato, we have seen it in Paytm, and we have seen it in many other companies. So never go that under the impression that all IPOs are good or NFOs are good. No, you have to apply your own mind, and obviously, you cannot go by what is recommended on the WhatsApp chat. So with this huge infrastructure, out of 130 crores, we have 7 crore accounts. And 50 lakhs accounts of DMAT, they just came into existence only because of LIC IPO. LIC offered very big discount to, I think 60 rupees discount to the policy holders, and they made a good reservation of shares for his policy holders. Unfortunately, the stock has not done well, and obviously these 50 lakh people who have suffered the loss immediately on their entry to the capital market will take many years to get courage to get back to the market. Of course, the idea behind it was inclusion of more investors, but market is above every thinking. Market is 12 merchant bankers were there, company was there, government was there, but the pricing, it appears, was not good. I myself applied for it. Luckily, I didn't get full allotment. I get part of allotment. But that is a part of the, investing. You learn, you earn, you learn, you earn. This cycle goes on. But I can tell you, the future of India is good. It's going to be, I read somewhere that Nifty and others will be 2023. It's going to touch around 19,000. So if you want to be, I think as a professional, whether we are a CA or CS or, in the field of finance, we should be a part of the capital markets. Still, it has to attract, the common person. Just 7 crore DMAT account is not enough, and they are not active. So active are only few. So still dominance of FPIs is there. I think the SEBI as well as the government has to create conducive conditions, and we as the auditors and contributor to the capital market have to make sure that the number of frauds, number of manipulative schemes, and number of substandard issues that comes down and attracts the investors to the market. We all have a contribution to make to the capital market. But as of today, it is not more. The whole money is stacked up in FDRs, in gold, and in real estate. So some of it has to move to the capital market. In USA, the market is $53 trillion, and they are number one. We are number 5 as of recent calculation. We are having 3.2 trillion. But just see the difference between the first and the 5. It is almost 16 times. So we have a lot of ground to cover. But in the next few years, India is going to rise. We have shown it through our technical skills, through our healthcare system, through our finance and legal professionals, that India can lead The brilliant minds are there, and earlier they were working for overseas countries. Now the emphasis is to contribute for their own economy, and that will bring a great change. And also the emphasis of the present government to make it a 5 trillion economy will come into place. So this is, with this background, let me now come to securities laws. Securities law is not only SEBI law. Securities law consists of 3 major legislation: Securities Contracts Regulation Act 1956, Securities and Exchange Board of India Act 1992, Depositories Act 1996. Securities contract regulation was essentially to control the exchanges and to oversee the listing process and the listing guidelines. And after 36 years of our experience, we came with the different legislation which now takes care of all the 3 components, that is regulation, investor protection, and development in 1992 by way of SEBI Act. Then a need was felt that our process is very cumbersome. It is so much of paper oriented. Tons and tons of papers are being transported from the broker's godown to other places. So how to do it, make it DMAT or, statement, this thing, electronic holding. So that is how the DMAT holding concept came, and it has caught up very well. I think depositories are doing very well. They are trying to include a lot of other products also into it, and outcry system is all totally gone. In terms of technology, we are number 1 in the world by way of number of trades, but obviously the value of trades is not that high. The moment it becomes moderate and it catches up and more investors participate, the day is not far when we will become number 3 or number 2 or number 1. But all of us will have to contribute in terms of taking interest in the capital market and also ensuring good corporate governance, good accounting disclosures, and good practices followed by professionals, because that gives a lot of confidence to the investors. Now, SEBI has been incorporated from 1988. I'm saying it again, 1988. It was a part of Department of Economic Affairs as a department. 12th April 1988, it was incorporated as a part of Department of Economic Affairs. It took 4 years for the legislation, that is SEBI Act 1992, to come, and luckily also on the 12th April 1992, the SEBI Act came into being. The 3 objectives of SEBI are investor protection, regulation of intermediaries and companies, as well as development of the market. As far as first 2 are concerned, we are a bit convinced that yes, it has done a good job in its journey of 30 years. But as far as development is concerned, the question is debatable whether in a highly populated country like India is investor participation enough, and obviously the answer is no. The conditions have to be made more conducive. Investor education programs have to be run, and products have to be simple, and of course the frauds or the manipulative practices or unfair trade practices or insider trading, that has to be curbed. Then only this market will develop. We have seen recent campaigns of mutual funds, saying that mutual funds is sahi hai. Yes, sahi hai, but still there are 16,000 schemes in that. So what is sahi hai? We do not know. Which scheme is the best? We do not know. But at least we should take first step by analyzing in our own mind, choosing a portfolio directly of a company or of a particular scheme. Let's be a small investor. Let our journey of investment begin with tiny steps, and then it can take bigger and bigger shape. So Section 3, talks about incorporation of SEBI. Section 4 talks about the management of SEBI. It is governed by 9 members, and right now Madhvi Puri Booch is the chairperson, assisted by 3 whole-time members, Anant Baruaji, S.K. Mohanty ji, and Mr. Ashish Bhatia, who has recently joined them from SBI. One post is still vacant. Then there are representatives from Ministry of Corporate Affairs, Reserve Bank of India, Department of Economic Affairs, and also we have some representation from IIM. I am professor. This I have been campaigning for a long time, that SEBI should have some representation from the industry also, or from the professional field also. But on the board it is not there, but on some committees it is there. All the 3 institutes, they generally are a part of any big reform, which is being talked about. So 3 and 4 basically deals with the creation of SEBI as well as management of SEBI. It had 850 employees as of 31st March 2021. I feel the number should go, be double, because it's a huge market consisting of mutual funds and many products, AIF, FVCI, FPIs. I think they have a lot to do, 40,000 intermediaries, and so many investors to deal with. And this market is driven by greed and fear. So people adopt all types of schemes to make good, quick money, good money. Of course, it is not easy. Sometimes the path adopted by them, gets into the glare of SEBI, and they have to cough up more money than they ever made it. That we will cover. Huge powers are given to Securities and Exchange Board of India under Section 11. It says powers and functions of the board. 11.1 says duty to protect and the interest and develop the market, but such measures as it deems fit. Complete power is given to Securities Exchange Board of India by Parliament of India. They can do anything. They can stop a transaction, they can stop a person from dealing, and they can issue any circular. So wonderful power, fantastic power, 11.1, and to a great extent it has helped in maintaining a discipline and fear of the regulator. And 11.2 says it can provide for the measures which are required to attain the 3 objectives, which is investor protection, development, and regulation. And 11.4 says it may pass order for suspension or restraint of any company, any intermediary, or any exchange officials also, if it finds that the person is not working in the interest of the securities market. So these are tremendous powers given to it, and rightly so. Sometimes it is ex parte also. You come to know only by when your phone starts ringing, telling you, oh, you have been prohibited, and you do not know because no show cause notice is given to you. It is called ex parte order. SEBI knows what you are doing. It has surveillance system, it has information, and it has a GPS location also of your phone, fund managers, as well as intermediaries for insider trading, as well as front running. And ex parte orders are issued, and that becomes the show cause notice. So tremendous powers given to it, rightly so. Of course, SEBI is asking for phone tapping also. Government has not obliged so far on it. But my view is that it should not be given a tapping power, because already we have agencies who are working on a lot of tapping. So it should not. It should become a business enabler and not a too much of obstruction. As it is, we see so many orders, very strict orders are passed by SEBI. It does not spare anyone, right from Reliance to Infosys to Wipro. I think everyone has been cautioned on one account or the other. Even TCS has been issued a warning for inadequate disclosure under Regulation 30 of LODR, for the litigation it had in USA. And they made it a point to tell to the company that place this board letter before the board of directors, and also on the stock exchanges. A company like TCS, belonging to Tata Group. So SEBI is not afraid of any hard actions, but whether it needs to be hard in all situations, is it equipped to deal with so many cases? I can just share with you, SEBI has issued 14,722 show cause notices just for dealing in illiquid stock options. That was suggested by some people that it will save money by way of capital gains, creation of capital gains for some and capital losses for someone. But inquiry revealed by income tax authorities was passed on to SEBI, and SEBI has issued 14,722 show cause notices. Now the moot question is whether it can handle such a huge amount of litigation. Answer is no. Everything is choked up. So it also floated a settlement scheme specifically for illiquid options, but that gave them 105 crores and only 1,400 cases came. Still, large chunk of SCNs are there. People are going for appeal. Even SAT is choked up with that, and SAT has suggested of late to SEBI to come out with some scheme which is fair, equitable, and not very harsh. We are just waiting for flotation of that scheme by SEBI. Also, it has power. If you see, being in the finance field, you have a contribution to make. All the IPOs, FPOs, and right issues, they are cleared by SEBI. Draft offer documents, they are filed by merchant bankers on behalf of the company. Then they get vetted by the SEBI, and SEBI says that please strengthen the disclosures on so and so part, on litigation, on financials, as well as on the management, plus on the business side. That power is under 11A, power to regulate or prohibit issue of prospectus, offer document, or advertisement soliciting money for issue of securities. That is the power under section 11A. And SEBI, of course, makes money. If they don't do it for free, they charge money from the issuer, depending on the size of the offer. Also, they have tremendous power under section 11B, power to issue any directions. They can, in the interest of the securities market, to protect the integrity of the market, they can issue any direction to anybody, whether he's, if they suspect someone is working against the interest of the market or likely to come out with some scheme, they can prohibit his participation and also, freeze the bank accounts or securities account. Another power which is very frequently used now is the power of investigation under section 11C. It can, resort to 11C when it feels that the operations of a particular listed entity or intermediary or any of the investor is not being conducted as per the regulations. Then it can also summon the board of directors of the company, CFO, CS, or any other person whom they feel has been negligent in the market. Also, those entities who are receiving intercorporate deposits or proceeds of the listed companies from the IPOs, they get also embroiled in all the controversies. So that power is power of investigation, which gives them the power to ask for anything and to any document of the company, or they can summon the statutory auditors as well as secretarial auditor of the company. We have some cases where we are trying to protect the independent directors, statutory auditors, secretarial auditors, in the process. If there is any misstatement in the financial statements, then the board of directors complete, no exceptions here. Let's be very clear. It's not company law, it is SEBI Act, and it gives show cause notices or summons even to the independent directors for the allegations. And also the if there is any misstatement or breach of LODR or any other regulation, the CFO as well as CS, they are also summoned apart from the normal management. Cease and desist proceedings also under section 11D. If it after causing an inquiry, if it finds that someone has violated the SEBI regulations, then it can cease and desist the participation of that person also. So far we have seen section 3, section 4, section 11, section 11A, 11B, 11C, and 11D. 3 deals with incorporation of SEBI, 4 deals with management, 11 deals with powers and functions, 11A deals with sorry, I forgot. 11A deals with the issuance of prospectus, 11B deals with direction, 11C deals with investigation, and 11D with cease and desist proceedings. So now we come to section 12, which again is very important. What it says, section 12 says registration of all intermediaries. Now here it is a big business opportunity for all of us. 40,000 intermediaries are registered. They have to comply with very strict regulations of SEBI, and they need periodic network certificates, internal audit, IT audit, cyber security audit, etc., etc. All the intermediaries. So there, the role of professionals is there. Both chartered accountants as well as company secretaries, in that. And also they can help when the FPI or any institution wants to be registered as a merchant banker or a broker or an investment advisor or a research organization. The professional can help in registration of that. SEBI scheme, let me also tell you, in 1992, only 35 sections were there. And today, there are more than 80 sections in SEBI Act. And I'm talking about SEBI Act only. Regulations, rules, they are different. They run into 3 volumes. And unfortunately, there is not a single book on SEBI laws which covers the precedents as well as the case laws. We have a Ramaiya, for Companies Act to look at the history of, corporate laws, governance, management, directors, auditors, and shareholders' rights, etc. We have nothing like that in on SEBI. So everything one has to do on oneself to come to the applicability of a particular law. Unfortunately, the sites are also not that friendly. You have to really work very hard to get to the bottom of the issue. And that is a challenge. And that is why very few practitioners are there in this field, as pointed out by Dr. Rajkumarji, that it is a field which is dominated by a few players only. But is it impossible to learn? Obviously, answer is no. If I can learn as an accountant, as a company secretary, as a lawyer, why not you? With some efforts from your side, with some interest, you have to have passion about the happenings of event in the corporates. Just don't confine yourself to the accounting or the audit and the tax. See the flow of the capital market, how the stock price goes up, how it comes down, what contributes to the good governance, what contributes to the good disclosures. Keep an eye. Same field, 2 companies may be quoted at a difference of more than 50% of the price. The difference is good corporate practices, good accounting disclosures, and good governance. As Narayan Murthy ji said, that I was very keen that bad news goes as fast to the investors as the good news. He says we never try to hide it. And that is why he has created such a icon company in Infosys. We have to be very, very, the managements have to are rewarded for their transparency and for their quickness and completeness in the disclosures. So we have seen section 3, 4, 11, 11A, B, C, and 12. Now we come to section 15, which is most important. And let me tell you, 15A is ABCD, which means it goes up to Z. 15A to 15Z are very important sections. 15A deals with penalties, which may vary if you do not file anything with SEBI or stock exchanges. The penalties may be from 1 lakh to 1 crore. Then we have 15B for not having the agreement, same penalty. 15C, investor grievances, same penalty. 15D and E, they deal with mutual funds or asset management company. And 15F, it deals with the working of the stockbrokers. Again, the penalty is 1 lakh to 1 crore. No problem till F. But the moment you come to section 15G, which deals with insider trading, the minimum penalty is 10 lakhs or 25 crores or 3 times of the amount, whichever is higher. Here, the play comes, the threat comes from SEBI that don't try to be over smart before us. They have surveillance systems and a lot of other information which flows to them, and people who think after making money after 8-10 years, they can just be relaxing. Don't be under that impression. We have cases which go as back as 2000. The funds raised in 1998, show cause notice is issued in 2018 also. So SEBI does not spare anyone. So one has to be careful. Then we have section 15H, which is takeovers, again 1 lakh to 1 crore. Then we have another section which is very drastic, and that is section 15HA. It deals with fraudulent and unfair trade practice. There, the minimum penalty is 5 lakhs, which can go up to 25 crores or 3 times of the amount, whichever is higher. SEBI loves to invoke section 15G or section 15HA, wherever they get a chance to do it, because the penalty amount goes up drastically high. So 15A to 15HA is penalties, and whatever is not covered from 15A to 15HA is covered in 15HB. It is called residuary penalty clause, right? So hope I am clear on this. Then once SEBI comes to a conclusion that you have done something wrong, either it will give you an ex parte order because it doesn't have time. The speed is the essence in securities market, and greed and fear, they are the factors which lead this. So they may give you notice, they may not give you. If they don't give you notice, that is proceedings under section 11. And if they give you notice, it has to be as per the section 15I, power to adjudicate. And under that, SEBI has formulated adjudication rules 1995, which says that you have to be given notice, then you have to reply within specific time, and also you can be represented by yourself or through all the 3 professionals, or rather 4 professionals, that is chartered accountants, company secretaries, cost accountants, and legal practitioners. 15J, it says, talks about factors to be taken into account while adjudging the quantum of the penalty. The discretion is fully with the adjudicating officer. It is up to you how you make your case and give them full facts with documents and make it convincing that they charge you minimum or they exonerate you. It is up to you. If you neglect, at that time, 1 lakh case may become 50 lakhs case. And it is very difficult to get reversal from Securities Appellant Tribunal. I will deal with that when we come to that. But be very careful at the time of show cause notice only. We have many clients who come to us after the adjudication order is passed. We don't take those cases because it's not going to find any merit at Securities Appellant Tribunal. Because I will give you the data. SEBI does a lot of homework on its prosecution. So if you are neglectful at that time, then only God can save you, and it will result in the higher penalties for your clients. So 15 JA says that this is not the income. These penalties, etc., these are not the incomes of Securities Exchange Board of India. These all the money will go to Consolidated Fund of India. And of course, indirectly, SEBI chairman may be going to the Ministry of Finance and saying that, he has collected so much funds. So indirectly, he will be appraised on that. But officially, the money goes to Consolidated Fund of India. Now, once the penalty is put to you, or rather, once the show cause notice comes to you, there is something called settlement also. We will come to that in a while. But I want to tell you the section which deals with settlement is section 15JB, settlement of administrative and civil proceedings. So here also settlement amount goes to Consolidated Fund of India minus the legal costs and disgorgement. By the way, the disgorgement is covered under 11B, power of directions. Supposing I, as the fund manager of a mutual fund, did front running and I made 2 crores out of it, what are the actions which can come to me? 1, they will take away the 2 crores. 2, they will charge interest on that 2 crores. Right? 3, they will debar me from the market. And the moment they debar me from the market, I will lose my job and the future jobs. Plus, they will prosecute me under section 15G or 15HA. So this kind of smartness or over smartness is not at all recommended, because not only your job goes, but all your savings also go once you are prosecuted by SEBI. Now, then comes up to 15J we have covered, then 15K to L, creation of SAT, composition of SAT is there, and then U, what it says, the Civil Procedure Code will not apply to the proceedings in SAT, but principles of natural justice will be applicable. Now, section 15B gives power to all the 4 professions to be representation before SEBI as well as Securities Appellant Tribunal. And limitation, yes, limitation applies to SEBI proceedings as far as the appeal and timings on me are concerned, but limitation does not apply to SEBI on the cases which it can reopen. As I mentioned to you, 2000 case, the fundraising done in 1998 has come under scrutiny in the show cause notice of 2019 because there is no limitation bar on that. But what is the judgment on this from Supreme Court? It says it has to be done in a reasonable period. But what is reasonable period depends on the facts and circumstances of the case. No civil court has any power to enter into the SEBI domain or Securities Appellant Tribunal. It is exclusive jurisdiction, section 15Y, read with section 15, read with section 20A. So these are some of the important things about SEBI. I think section 19, it empowers SEBI to delegate these powers to any of its officers, which is normal, which is okay. Then the composition of the offenses, section 24 deals with if someone is trying to, or defaults in that, the imprisonment is 10 years or 25 crores of fine or both. So that is under section 24. Section 27, which is very important for all of us, you and me and others, because all directors, CFOs, CS, and other officers, they are covered under Section 20C, contravention of which will be dealt with in case of companies in accordance with Section 15I and the penalties which I have spoken with you under 15A to 15HP. Now, as I told you, Parliament doesn't have time to get into the nitty-gritty of all what is happening in the market. They have empowered SEBI to make regulation under Section 30. And I think hundreds of regulations are made for everything. There is a regulation, merchant banker, broker, rating agency, for LODR, there is a regulation. For ICDR, there is a regulation. Insider trading, there is a regulation. Takeover, there is a regulation. AIF, there is a regulation. For everything, there is a regulation. For settlement also, there is a regulation. So for everything, there is a regulation which is made by SEBI under Section 30 of SEBI Act. And further, the application of other laws is not barred. Other laws will also be applicable to you if SEBI Act is applicable. Then SEBI has extraordinary power to remove difficulty in case there is some distortion or there is a need for any clarity. Every day you find so many circulars coming from SEBI as well as the stock exchanges. So this is what is SEBI. I will just repeat the sections. Section 3, creation. Section 4, management. Section 11, power and functions. Section 11A, about raising of funds, prospectus. And 11B, disgorgement, directions. 11C, investigation. 11D, seize and desist proceedings. Section 12 is registration of intermediaries. Section 12A is prohibition of insider trading and fraudulent and unfair trade practices. Then 15A to 15HB, we have seen penalties. 15I is adjudication. 15J, factors to be considered while putting the penalty. 15JA talks about the money going to Consolidated Fund of India. 15JB talks about settlement of the administrative proceedings. Then 15K, L, M, etc., creation of SAT and composition of SAT. And under Section 15T, any order of under Securities Contract Regulation Act, SEBI Act, or Depositories Act, any order, if you are aggrieved, within 45 days, you can appeal to Securities Appellate Tribunal, which is situated only in Mumbai. It is a super appellate tribunal where very high level of discussions happen, because it is the only tribunal, unlike NCLT, or NCLAT, where we have many benches and they are at many places. It is centralized and it is manned by a very experienced person who not only know the capital market, but they also know the nuances of the law. And if you are not happy with the verdict of Securities Appellate Tribunal, you can go to Supreme Court under Section 15Z. That will be only on the questions of law. So it is very, very, very much advisable that at the adjudication stage itself, before SEBI, you give all the facts and all the documents. And if something is left out, that you can give at Securities Appellate Tribunal, because straightway the matter will go to Supreme Court. 4S, you remember, in securities market, stock exchanges, SEBI, Securities Appellate Tribunal, and Supreme Court. No one else, no High Court has any power on this. Even if you go under 226, 227, the High Court will say that there is an expert tribunal. Why you are bothering us? It has happened recently in Kotak Mutual Funds case, whereby Bombay High Court says that you have got an alternative, place for your grievance. So don't come to us, don't bother us. So it's a specialized tribunal, and it very good judgments have been there, though it is supposed to dispose of matters within 3 to 6 months, but actually in many cases, because of the complications, SAT takes more time, but still it is an efficient mechanism because money is involved, big money is involved. We have cases which are, which I think touch some of the cases I will touch. But before that, I think whatever I have covered, let me give opportunity to the participants to ask me questions. So may I now request Lokesh ji, whatever questions are there, I can, have a answer them.
Yes, sir. There are few questions.
Yeah, just see that repetition is not there
Yes, sir,
from your side,
definitely.
because we have a lot to cover.
Yes, sir. The first question is, does SEBI has power to prosecute CA if CA has no connection with the alleged misstatements of accounts?
If he has not signed the audit report, then he cannot be prosecuted by SEBI in his capacity as a chartered accountant. But if he, as an investor, is doing something wrong or advising the clients violating the investment advisory or merchant banking norm or stockbroking norm, then only he can be liable, but not as a CA. As an individual, any person, the word used is any person, and in any person, all of us come. If we are contributing to the breach of any regulations, we are liable for it.
Sir, the next question is, what is the solution for freak trade, which costs so much without fault of a person? What action SEBI has taken on this?
Freak trade.
Yes.
Which means error. Because error due to the punching or technology failure. I think SEBI has been very harsh when the trading was halted at NSE. SEBI has really penalized the company, that is National Stock Exchange, in a very big way, including their chief technology officers, and a committee has been put up under the chairmanship of former whole-time member who is former deputy governor of RBI, Mr. Mahalingam, very eminent person, IIT IIM, to strengthen these systems. So SEBI is very, very, very what you call careful about the integrity of the market and integrity of the system. I think the biggest penalty that has been given to National Stock Exchange is 687 crores plus interest. So as of today, it becomes 1375 crores plus every day something or the other. We keep hearing prosecution against Ravi Narayan, Chitra Ramakrishna, and Subramaniam and others who have done wrong to in the market. So latest on this is freak trade. If it is a technology failure, yes, SEBI is strict, but some accidents will happen. If they are bona fide and everything has been done, then it declares those trades as null and void.
Okay, sir. The next one is not a question, I think, but it is like an information. Sir, you have said that there is no book on SEBI laws that give reference to the past precedents and case laws. I am happy to report that my book titled In and Out of the SEBI Takeover Code, Buying and Delisting Regulation with Investor Protection Guide, has just been launched. This book quotes past precedents and case laws extensively. The member here
I know the person, and I've seen the book also. I congratulate my friend who has written it. I have seen that book, but it is, as the title itself says, it talks about takeover and insider trading and some part of LODR. But that is not enough. That is not enough, I can tell you. But a good effort has been made by my friends. I compliment him for that and wish him all the best.
That's all for the queries, sir.
Okay. So how many people are there? How many people are there, sir?
1 minute, sir.
Now I am taking the most talked about subject.
658, sir.
Oh, very good number. Okay, so I'm enthused. I'm enthused. Okay, so no one wants. Okay, let's have a look at some of the orders. And let me put it on the screen itself, because people love to see the screen and read it with me, right? Okay. Few regulatory orders. Nothing in lakhs. We will talk in crores only. Okay. So SEBI asked Reliance to disgorge 447 crores with interest of 12% from 2007. As of today, obviously it is more than 1,000 crores. SAT has upheld that order. They have gone to Supreme Court. Supreme Court says deposit 500 crores and then we will hear you. Also, in the same case, Reliance has been, as I told you, that was just disgorgement. Penalty यहाँ पे है. So यहाँ पे 70 crores penalty has been put, including 25 crores to Mukesh Ambani ji. Right. So this is what is the thing. Then Axis Bank 5 lakhs recently. Somebody was doing a TV host, Hemant Gai. He used to recommend some of the stocks and take the contra position, 2.95 crores, apart from humiliation as well as market ban. Fund manager of Deutsche, for gain of 1.42 crore, he had to give up 5 crores. And let me tell you, it is not monetary only. He loses the job. No one will take him in the employment anywhere. So one has to be very, very careful while dealing with UPSI. UPSI, by the way, applies to all the lawyers, auditors, secretarial auditors, tax auditors, everyone. SEBI strikes Franklin. I think Franklin was debarred from coming out with any scheme. Later on, they got some relief from Supreme Court, but SEBI used its extraordinary powers under Section 11B, to do that. NSE, as I told you, Mahalingam Saab, one of the best whole-time members of SEBI. He issued order of 625 crores, and then there is another order of 62 crores. So 687 crores हो जाता है, plus interest लगाओ, तो उस पे आज की डेट में ज़्यादा है. The matter is heard, and verdict of Securities Appellate Tribunal is likely to come anytime. And my view is nothing is going to change. This is going to be upheld. Corporate governance also, negligence, of NSE, etc. was there. So Mr. Mohanty, he ordered the third order. He issued the third order against SEBI. Again, a lot of people are restrained from the market. They cannot be director. They cannot be a part of the market at all. Also, NSE gave, golden exit to Chitra Ramakrishnan. The whole board is under glare and proceedings are on. And I think in February, March, we saw a order, very comprehensive order from Anant Barua Saab, which really, has now brought in CBI, Enforcement Directorate, and all agencies of the country working against Chitra Ramakrishna, Ravi Narayan, as well as that Subramanian, who was appointed as the CEO. Okay, India Bulls Ventures director and his wife disgorged 87 lakhs. SEBI puts penalty of 10.75 crore on Aksh Optifiber. SEBI bans Aptac Limited and MD for fraudulent GDR. Then 1 crore on Yes Bank promoter companies under takeover regulations. Nesvadia, he settles for 87 lakhs for not disclosing his arrest in Japan. Then WhatsApp group, some messages were there. SEBI took action, but SAT has struck down that order, and SEBI obviously has gone in appeal before Supreme Court. So these are some of the orders of SEBI. I think you all are very keen to know about the settlement or consent proceedings. I think before that, if you give me a 1 minute break, I would be obliged for that. Lokeshji, a 1 minute break.
Yes, sir. Surely, sir. Surely.
Thank you. I am obliged. So many people think, settlement, consent proceeding kar lijiye, but they do not know what it is. Earlier, there was a circular on settlement, but number of cases increased, complexity is increased, and once the vakils, they come into the domain, they increase their own work. So SEBI was compelled to come out with SEBI Settlement Regulations 2018. Earlier, as I told you, it was a circular and then 2014 regulation. And now with effect from 1st January 2019, these settlement regulations have come into play. They are very simple, but very effective. And let me tell you at the outset itself, it is a very costly affair. Settlement proceedings, consent proceeding, or plea bargaining, whatever name you may take, or compounding, it is the same thing as far as SEBI laws are concerned. And which are the SEBI laws? Securities Law, Depositories Act, SCR, and SEBI Act. So with effect from 1st January 2019, these new proceedings, regulations have come. And as I have said, this is for rich and powerful only. I will prove that to you. We have cases where mutual funds are paying 14 crores. HDFC Mutual Fund, SBI Mutual Fund, others have paid in crores for settlement fee. Obviously, it is not for innocence. Market understands it. Their unit holders also tell them, what are you doing? So Rakesh Jhunjhunwala also settled for 40 crores because these people can afford. But whenever it comes to CFO or CS and compliance officer, we are very careful. Why? Because it is a costly affair. And secondly, knowingly or unknowingly, once the name comes, it is always a drag, or something you have to give undertaking that you are not, you have not been penalized or no settlement has happened or anything like that. So like that, this settlement process is there. Sometimes the settlement is much more, sometimes most of the time settlement is very costly than the normal thing. But the saving grace is that you are saved from the time. Your time, etc. You save, you pay, and move on in the life. So that is the advantage of the settlement. Where is the screen? I've lost the screen. Yeah. Okay. As I told you, Section 15 JB, it allows settlement proceedings. Sorry, my WhatsApp is giving this noise. I want to put it off. Okay. So 15 JB, as I told you, read with Section 24A. 24A is for criminal this thing. We are not concerned with that. As far as this settlement is concerned, only 15 JB, only administrative and civil, which means Section 15A to Section 15 HB, 11, 11A, B, C, D. Everything is covered here. You can do it at your own, and you can do it at your own suo moto, or after receipt of the show cause notice, or even after filing the appeal with Securities Appellate Tribunal. I am going to tell you some of the key points only. A person against whom any proceedings have been initiated, are pending, or may be initiated may make an application to the Securities Exchange Board of India under Regulation 3132 of Settlement Regulation. Application needs to be verified and affirmed, and the contents are to be this thing. Then undertakings and waivers, they are given that no appeal, full disclosure I have made, and amount will be paid, and I will not make any public statement. I will not go to the media, and I will not appeal also. Is undertaking is given before settlement proceedings are debated. Then non-refundable fee of 25,000 rupees for corporates or 15,000 for individual had to be made by way of online. Now, application has to be made within 60 days of the issuance of show cause notice or supplementary show cause notice. Earlier, under Section 15.2, there was under Section 4.2, there was a provision, of making it beyond 60 days and paying 25% extra. From 14th January, this has been taken away because there was gross misuse of it. So all disclosures need to be made in the settlement application, and SEBI may not settle it if it has market-wide impact and it has caused losses to large number of investors and it has affected the integrity of the market. SEBI has sufficient powers to reject any application. In fact, 1/3 of the application they get rejected, as I will share the data with you. So one is it is not properly made by the professional. Two, when the query comes, they don't respond on time, so it gets rejected automatically. There is a concept of summary settlement for small things. In the show cause notice itself, they may say that you pay this much money and we will let you go. But we have yet to see any case of summary settlement. It is done for very minor offenses. And any application can be withdrawn at the any time prior to the communication of this thing. ICC internal committee will recommend you once they go through your application, then they tell you the amount, and minimum amount which you have to offer is 3 lakhs plus other restrictions if at all the matter is serious. So this 3 lakh may become 15 lakhs. They will say in ICC, no, you pay 15 lakhs. It is up to you. Within 10 days, you can accept it or reject it. If you reject it, the show cause notice proceedings, they will continue. So obvious, as I told you, even the settlement fee which SEBI takes, it goes to the Consolidated Fund of India. Information required, very normal information, but give full information. We are working on 5-6 settlement applications, and we are making sure that the details of show cause notice, the details of the offenses, the ex parte order, plus all the details are fully given to SEBI so that our application is not rejected. Now, comparison of adjudication with settlement. Adjudication is initiated by SEBI and settlement is initiated by applicant. No fees in adjudication, 15,000 or 25,000 for settlement, and adjudicating officer decides the penalty. Here, internal committee, high power advisory committee, which consists of high court judge, a lawyer, a finance person, and some representatives of the SEBI. They decide about the settlement amount. Stigma, I think adjudication is attached, but I think since the orders of settlement, they are in public domain, I don't think stigma can go away. No appeal lies in the settlement. Guidelines for arriving at the settlement amount, since the money involved is very high, it is done by best of the brains, that is engineers, lawyers, accountants, and legal guys, to make sure that the formula is foolproof. Like indicative amount is equal to A into B, where A is proceeding conversion factor and all that. I think if I tell you, whole day will go. I will give you a live example of it, of the case that will drive home the point very well. I think this is the one. I don't know whether you can see it or not, but let me make it full screen. Yes. So here one company was there, FUTP, that is a 15 HA regulation. They took the base amount of 1 crore. LODR regulation, they took 15 lakhs. The base amount became 1,15,000. They, multiplied it by 2, it became 2 crore 30 lakhs. Then proceeding conversion factor and regulatory action factor 85. So it became 195. Then they added 25% for application beyond 60 days. It came to 2 crore 44 lakhs for the company. And for director and CFO each I am saying, it became 1 crore 16 lakhs. So 1 crore 16 lakhs into 8. So whatever it is plus this. So this is how it is calculated. As I told you, it is a very what you call a costly affair. All cannot afford this, and generally it is very costly, as you can see it. And the calculation is quite complicated. So I have given you the formula for it. HDFC mutual fund, they did it for 4.2 crore. Indigo 2.10 crores, then Sun Pharma 2.95 crore, and we have the latest one 10.5 crore from Religear Finance, and one of the other companies paying for this. Then yes, settlement in 2021, 318 plus 239, 318 applications were pending. 239 were made, 187 got rejected. So you just see, more than 30% of the applications, they get rejected on settlement because they are not made properly. 2, the queries which are received from SEBI, they are not answered within the time frame. So after some time, SEBI closes, and once the application is rejected, you cannot revive it. Another point is, you cannot force settlement on SEBI. It is a consensual act. Bombay High Court in Reliance matter has very categorically said that if SEBI doesn't want to do your settlement, you cannot compel them. It is a consensual act. Okay. So this is what is on this thing. SAT we have covered. 15T I have told you already. Within 45 days, you have to approach. For Securities Contract Regulation Acts, Depositories Act, and SEBI Act. And 15K we have discussed. Then we have very eminent board tribunal. I will just show you the picture. Honorable Justice Tarun Agarwal. He is a judicial member, presiding officer, and he's a third generation judge. In his blood remains the ingredients of dispensing justice, as we say. Then we have Mr. Joshi, former Bombay High Court judge, and then Meera Swaroopji is there from Indian Economic, from IA, Indian Audit and Account Services. 3 judges bench, only 1 bench in the country, but well constituted. Procedure, as I told you, SAT 45 days you have to go. Then presentation of this thing. What you have to do in appeal is a list of dates and events and synopsis. You have to be very good in that, and then only you can make. Even for SEBI adjudication notice, you should be doing LODE. One is LODR, another is LODE. LODR we all know, because our responsibility is directly under them as the auditor or as the finance officers. But LODE is list of dates and events. So once you do that, you will be able to know which section applies and what are the facts. Be thorough in your facts as well as in your presentation of your part, and put all the documents. Remember, you cannot go to Supreme Court on the basis of any facts. There only the principles will be considered. So fee structure is, for 25 lakh penalty, the fee payable to SAT is 30,200, which means 1,200 basic and 500 rupees for every lakh of rupees. That's it. I think, what is the time? We have 5:35. Okay. Supreme Court and SAT decision I can talk about. Shriram Mutual Funds case, Supreme Court says mens rea, that is intention, it is not an essential gradient for contravention of provisions of the Civil Act. Penalty is attracted as soon as contravention of the statutory obligation is done. And SEBI is extensively putting that in their show cause notice. Once the contravention is established, penalty has to follow. No intention, no mens rea works here. Bhavesh Pawari's case, which was again a landmark case, on 28th February, Supreme Court has said that adjudicating officer has all the powers to decide the quantum of the penalty. He may or may not put penalty even, and he's not bound by minimum and a maximum. In this sense, he can put any amount after giving the reason, but he has to consider the mitigating factors, which we talked about in section 15J. What section 15J say? There are 3 mitigating factors. 1, is it a repeat offense? Is it affecting the market? Have you made extra money? These are the mitigating factors. If the answer to all is no, obviously maximum penalty will not be there. But Supreme Court says that apart from these 3, you can offer other arguments also, and adjudicating officer, that is SEBI, will have to consider that, and while fixing the quantum of the penalty. Sahara India, we have said anything, initials or debentures or quasi securities issued to more than 49 persons will be a public issue, and they will be liable under section 11A plus relevant provisions of the Companies Act. SEBI has initiated action against thousands of companies based on this judgment of 2011. In Raju's case, insider trading regulation, reasonable expectation of access to UPSI was discussed, and the Supreme Court has held that preponderance of probability is very important. Now, here I would like to add that one latest judgment has come in April 2022 in the case of PC Jewelers. Now that has also touched this point, and Supreme Court has taken a bit different, view on that UPSI. It is called Shivani Gupta and others, decided on 19th April 2022, where this preponderance of probability principle has been expounded further, and the Supreme Court says that it cannot be entirely on the basis of circumstantial evidence. There has to be much more to that, and also the relationship itself is not enough. There has to be some action on that. So it's a very good judgment, but it looks like SEBI will go for the review, or would have already gone for it. And let's see how is the final verdict on this. But if it holds good, I think it will give relief to a lot of people who are charged under insider trading or unfair trade practice just on the basis of circumstantial evidence, that is preponderance of probability. Supreme Court has said here the expression reasonably expected cannot be a mere ipse dixit. There must be material to show that such person can be reasonably be so expected to have access to UPSI. And further, they say the fact that he was a co-brother of so and so without more cannot be stated to be a foundational fact. So I think if it judgment is upheld in the sense, if it fails in the review, it is going to be a big challenge, and a lot of people will get relief from fraudulent and unfair trade practice charge as well as insider trading. So I think these are some of the cases. Now, I can tell you, as I have been saying earlier, if you are not happy with SEBI order, you can go to Securities Appellate Tribunal within 45 days of the receipt of the order by email or by speed post. And if you are not happy with the order of Securities Appellate Tribunal, you can go to Supreme Court within 60 days of the receipt of the order by speed post. But caveat is, it can be done only on the basis of principle, legal principle, and not what you call facts. So what is legal principle and what is fact, I think I'll show to you. 15Z, you can go within 60 days to Supreme Court. And as I told you, in securities market, 4S works, that is stock exchanges, SEBI, SAT, and Supreme Court, right? And 15Z gives you 60 days to do it. And there are Supreme Court rules 2013, which are issued under Article 145 of Constitution of India, under which the appeal lies. Question of law and question of facts, as I told you, only question of laws involves the interpretation of principles that are potentially applicable to other cases. In contrast, a question of facts require an interpretation of circumstances surrounding the case at hand. Resolving questions of fact is the chief function of the jury. A question of law involves the interpretation of principles that are potentially applicable, right? So arising out of such order, sometimes many people just for the sake of going to for appeal go to Supreme Court, and going to Supreme Court means very heavy expenses for drafting, filing, and engaging of counsels. So one has to be very clear on the facts as well as the principles which have been missed out by SEBI or by SAT in such cases, and then only decide to go to Supreme Court. Sometimes they take 30 seconds to dismiss the appeal, and sometimes 5 minutes if the lawyer persists. I have also gone to Supreme Court with the not directly, but I assisted the senior counsel, and it was really tough to get any relief from them. Better you get relief and make a proper case at SEBI level itself or at SET level. In fact, I would say SEBI level itself, because SET also does not have too much time, and Supreme Court, obviously because of other cases, has very little time to dwell on this. So these are the things. Now I will tell you status of appeals. Just for 2021, we will talk about it. Appeals pending at the beginning of the year were 479. Appeals filed 545. Appeals dismissed 236. Appeals remanded 32. Appeals allowed 69. SEBI order upheld with modification 38. Appeals withdrawn 17. Appeals pending as of 1st April or as of 31st March 2021 is 632. Let us see what is happening in the Supreme Court. Supreme Court has 31st, as of 31st March, 356 appeals pending, 177 filed by SEBI and 179 filed by other parties. Here also the pendency is very high because high stakes are there. My feeling is that Supreme Court should be quick enough to dispose of the appeals. I have seen an order which has come recently, but this appeal is of 2013, disposed of in 2022. It contains 85 pages. So 9 years it took for them. But the good thing is, May 2022, someone has gone for appeal, and within 15 days, the order is upheld, and the appeal is rejected by a bench led by Justice Chandrachud, and order is only of 15 pages. So we see the extreme, views here. One, very good, very efficient, and another taking 9 years. So with that, I will close my talk, and I will invite questions, if any, from you guys. Thank you so much.
Thank you so much, sir. That was really very, very enlightening for us. As you have already said, there is no book on SEBI. So that was really very good knowledge for all of us. Yes, there are a few questions. One of them is, stock exchange is dealing on behalf of buyer and seller without disclosing their identity by way of transaction recorded in contract notes. In case of illiquid stock, what is liability for stock exchange who introduced the illiquid stock? Does the investor liable for liability of stock exchange?
It is a very good, it's a very good question. But unfortunately, stock exchange, who was controlling the mechanism of these stock options, they have not been penalized. And only the investors on both sides, that is buy and sell sides, they have been penalized, and that is under fraudulent and unfair trade practice, again that section 15 HA. So this matter has gone to SAT, and SAT has also not taken any view on the inefficiency of the stock exchanges on this. I think few PILs were also put in, if I remember it correctly, but they got dismissed. So all the burden has come on the investors only. But let me tell you, and being very impartial, this scheme was floated by a few of our friends to circumvent the income tax system liability of capital gains, creating capital gains for someone who needs it, and capital loss for someone who knows it. So they devised it. Securities Appellate Tribunal has taken a very fundamental view. Why you should take a loss or within few seconds of your dealing. Based on that, I think Good Earth one judgment they have passed, all the appeals are getting rejected, and minimum is 5 lakhs and then it is going up to 20 lakhs, 30 lakhs also in some cases in illiquid options. But stock exchange is not affected, though that is one of the factors which is considered. Let me tell you that the stock exchange may not be penalized, but you are given the benefit. They are not putting you 25 crores of penalty. They are still putting you either 5 lakhs or 10 lakhs or 15 lakhs or 20 lakhs. I think you should be happy with that.
Thank you, sir. One more query is that, as you pointed out, many investors have lost money due to substantial fall in post-listing price. 1 minute. Post-listing price in the case of Zomato, Paytm, LIC, etc. What action has SEBI initiated against these companies for improper/inflated valuation, which misled the investors?
You see, the stock market is full of surprises, and we are driven by the market, which means it is a disclosure-based economy. They tell you risk factors in 30 pages. You never read that. Only we read it when cases come to us, or the person who has drafted it, they read it. None of the persons in between read it. We go by, emotions or the casinos, as our great friend Mr. Warren Buffett has. So stock exchange is full of surprises. Best thing is to use your own mind and not get carried away. Let me tell you one thing. In Paytm, as well as in Zomato, I did not invest. But I invested in LIC. And after suffering loss, I'm not blaming anybody. I'm saying it was my call and I will suffer. No problem. So take the responsibility on yourself in terms of investing also, making money also, and incurring losses also. Both ways you get rich. One by experience, another by money. But my humble request to all the participants is be a part of it. Start with SIP. Systematically important some plans are there.
Investment plans.
Have something. थोड़ा मजा आएगा पैसा जब बनेगा और थोड़ा दुख लगेगा जब पैसा जाएगा. लेकिन मार्केट जो है गुरु दक्षिणा बहुत लेती है, इसलिए घबराइए मत. Eventually you will make money, but initially you may lose money and you will have to pay guru dakshina to the market. No learning is free in this. And no action can be taken by SEBI because it is disclosure based. At the most, they will ask some explanation from the merchant bankers, high-five merchant bankers, 12 के 12 जो हैं, अभी मैं नाम नहीं लेना चाहता, कहीं मेरे ऊपर ही केस डाल देंगे भी मैंने क्यों उनका नाम लिया, लेकिन सब वो आप जानते हैं. Every issue they are there and they feel they are very smart. Where is the smartness? Even in a best run company which makes 40,000 crores only from the market, 40,000 crore they have made last year only from the market by taking contraposition. उनका स्टॉक ही थूक गया हो तो अभी क्या करें? Where is the wisdom? Where is the valuation basis? Where is expertise? So it is all your risk. Sometimes you may be brilliant in discarding their opinions, and sometimes you may be foolish to discard their views. So it is both ways. So be an informed investor yourself. Do the research yourself and don't blame anybody else. And don't believe merchant bankers or anybody else. Use your own mind. People, I tell you the similar thing. I think Ruchi Soya, FPO came, very few people applied. But the stock is still, I think, 900. I have not sold it. I got it. Full allotment came. So it is all part of the game. Capital market is full of uncertainties, but still excitement and money can be made in it.
Sir, I think the idea behind this question was to raise objection on the improper valuation. I mean, we also think that if their share is valued so much, the company is a unicorn. So how can it fail, etc., sir?
You see, yeah, they would have taken, when the valuation is done, there are disclaimers, and it becomes a what you call big task itself to understand what are the disclaimers. So disclaimers are so high that you cannot hold them liable. Also, risk factors, it is written that valuation may be high, the stock may not open at this thing, so you are bound by that. What can SEBI do? In free economy, they are giving you free this thing. If it is book built process, I think there will be some good players, some bad players. But I can tell you that if there is any negligence on the part of merchant bankers in overall disclosures, they will not leave it. But not merely on the price, they will go after.
Yes.
I have to be very frank and honest with you, because it's a free economy, free pricing, disclosure based.
Correct. We have few more questions. Can an auditor be prosecuted by SEBI in case of dispute between two promoters by referring financial statement prepared by one of the promoters?
I think it is a very good question coming. In fact, I have not referred to it, but it's a good question. Price Waterhouse, in their role in Satyam, they were asked to give back the money which they have taken as fee. That is under section 11B. SEBI also debarred them from taking any fresh assignments. Matter went to Securities Appellate Tribunal. Securities Appellate Tribunal said that this disgorgement is okay, but banning is not okay, because that doesn't come under SEBI's purview. The matter has gone to Supreme Court, where this part of the SAT order that SEBI cannot take action against auditor has been stayed. My personal view is that whether it is an auditor, financial or secretarial or corporate governance certification, I think for listed companies, for intermediaries, everything should be decided by SEBI, because they are fast, they are impartial, and they are subject to legal scrutiny. And the stake of the market, integrity of the market, is much more important than few professionals who indulge in wrongdoing and thinking. Because of few people, these two prominent professions, they get bad name, they flag, and the headlines are made. I think with utmost respect and responsibility, my humble view, I belong to all the three professions, that's legal, accounting, as well as secretarial. My view is SEBI should have that power and not the concerned institute. Because if few people are trying to make money in a quick way, they have to be stopped, and the good of the many should prevail. That is what is my view. So I think it has answered indirectly what my friend has asked. Yes, I'm handling cases where auditors, secretarial auditors, independent directors, chairman, CFO, CS, all are summoned. And SEBI has the power under section 11 to go against them under 11C, 11D, as well as 11B. And then it will result in 11B action, restraint can be there, and then 15A to 15HB penalty can be there. And it is for auditor as well as secretarial auditor or internal auditor or whosoever, even the valuer also. Because valuer sometimes can be a merchant banker also, and not necessarily accountant.
Sir, the last question. Please clarify whether the amount ordered to be paid by the company has to be remitted by the officer, director, promoter personally, or the company shall pay it. In each of the case, whether amount paid, is it to be treated as business expenditure allowable in computation of taxable income in respective cases?
First of all, if this liability is personal, obviously that person has to pay. But if the liability is joint and several, then the company can pay. Now, what is the treatment under income tax? Let me just tell you, though I am not an income tax expert, but as a student of law, I will give you the answer on that. I have already covered it. Penalty cannot be treated as an expense.
Exactly.
So it will be disallowed to the company. But I think settlement fees can be. But then just for income tax benefit, why should you pay 4 or 5 times? Right? Exactly. Common sense says that don't look at income tax. Have more income to pay income tax. Don't restrain your income because of income tax. I think we have to change our mindset also. I told one entrepreneur who was incurring losses for so many years, and then he had to pay advance tax because he made money. He said, I'm very happy. All the losses are gone and I am paying now advance tax. So let's have an outlook like that. If the income rises, GDP rises, our own fee rises, it is good for the economy, good for the nation, good for everyone. So let's not be getting into the web of only income tax. And income tax is like zigzag. The moment I open that book, it says me go this way, and then it says me come back, and then it becomes a zigzag, big zigzag. I think Income Tax Act also needs to be simplified in a very drastic way. I do not know why the government is not doing that. But anyway, that is my personal comment. And of course, experts are there in you on this subject.
I think there are no more queries. All the queries have been solved. So, sir, from our committee, on behalf of the committee, we would really like to thank you so much for your enlightenment on the topic, which we deal almost every day. Almost every one of us come around stock market, stock, shares, SEBI, but we do not have so much knowledge. We try to acquire it from different sources, but this comprehensive knowledge that you have given, this concise knowledge is surely going to help all of us. I don't think there are further any queries. So, Krishnakantji, can we just wind up the session?
Yes, sir. Yes, sir.
So if you give me a minute, let me
Yes,
thank the organizers, that is the Institute of Chartered Accountants of India, my friend Dr. Rajkumar ji, Hansraj Chugh ji, Lokesh ji, and Krishan Kant ji, Reena ji, and others who are involved with this. It was a great interaction, and I feel really happy that I could be a part of this. As I told you, accounting is very important. Take pride in that. Yes, it's not to be taken lightly. Accounting is the foundation of everything. So once the accounts are okay, true and fair, really, the stock market and your own value will go up. And I wish all the participants all the best. And feel free, though I have not said it, but I can now say it. Those who want free updates, no obligation of any reference. We don't need any work or referral. Those who want to be a part of our broadcast, they can say hi, write their name and place where they stay. We will give them updates on corporate laws by way of broadcast, including SEBI, company law, FEMA, PMLA, and others. So that is our endeavor, just to help our professional colleagues, not with any business. So thank you all. This is what I want to say. And believe in yourself. Believe in yourself. Have faith in yourself. You will do wonders. That is my message to all the youngsters. You can do it. You can do it. Thank you.
Thank you so much for your inspirational words. Thank you so much, sir.
Thank you.
Thank you. We'll wind up the session.